The Supreme Court is currently hearing arguments in a case that could change federal gun law for millions of Americans. If you use marijuana, even legally under state law, you're currently prohibited from owning firearms under federal law. The penalty? Up to 10 years in federal prison. But this Supreme Court case, being argued in March 2026, could completely reshape who's allowed to own guns in America. Hit that subscribe button right now. This affects anyone who's ever used marijuana and owns guns, anyone thinking about buying a gun but uses cannabis, and anyone who cares about how the federal government strips constitutional rights based on substance use. Here's what's happening. The Supreme Court is reviewing the federal ban on firearm possession for marijuana users under 18 USC Section 922(g)(3), which prohibits anyone who is an unlawful user of or addicted to any controlled substance from possessing firearms. Marijuana is still Schedule I federally, meaning even state legal use makes you an unlawful user under federal law. Let me break down exactly what this case is about, why it matters even if you don't use marijuana, how the Supreme Court could rule, and most importantly, what you need to do right now if you're caught between state marijuana laws and federal gun laws. Number 1, the current federal law prohibiting marijuana users from owning guns. Under 18 USC 922(g)(3), it's a federal crime for any unlawful user of or addicted to any controlled substance to possess any firearm or ammunition. Unlawful user is interpreted broadly. You don't need addiction. You don't need daily use. You don't need to be high when possessing the gun. Occasional regular marijuana use makes you an unlawful user under federal law. When buying a gun from a licensed dealer, Form 4473. Question 21E asks, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? Answer, yes. Dealer cannot sell. Answer, no, while actually using marijuana. Federal felony for lying on the form, up to 5 years in prison. State legalization doesn't matter. As of 2026, 38 states have legalized marijuana, medically or recreationally. But marijuana remains Schedule Y federally. Federal law trumps state law. Even perfect state law compliance means federal law violation. Enforcement is inconsistent. The federal government doesn't prosecute every marijuana user with guns. But when enforced, penalties are severe. People are in federal prison right now for this. If you're finding this helpful, imagine what you'll learn in my next video where I break down the other prohibited persons categories that might be challenged after this Supreme Court decision. Subscribe right now because those categories affect way more people than you think. Number 2, why this case reached the Supreme Court. The case challenges whether the federal marijuana user prohibition violates the Second Amendment under Bruen's 2022 decision. Bruen established gun regulations must be consistent with America's historical tradition. The government must show regulations are rooted in historical practice, not just claim public safety. The challenge argues there's no historical tradition of disarming people based on substance use without criminal conduct or mental incapacity. In the founding era, people drank alcohol, sometimes heavily. No laws prohibited gun ownership for drinkers, only laws against drunk and disorderly conduct. The government argues historical tradition includes disarming dangerous individuals, and unlawful drug users pose danger. They cite surety laws and going armed laws from the founding era, allowing disarmament of threats. But the weakness? The marijuana prohibition isn't individualized. No showing a specific person is dangerous. It's categorical. Use marijuana, you're prohibited. No assessment. No due process. Just blanket prohibition based on substance use. The court also considers potential federal rescheduling impact. If marijuana moves to Schedule III or lower, the entire framework changes. Marijuana users might not be unlawful users. If marijuana is no longer federally prohibited for medical use. Quick legal note. This is educational information about pending Supreme Court litigation in federal firearms law. This is not legal advice for your specific situation. If you use marijuana and own firearms, or if you're facing federal charges related to this prohibition, you must immediately consult with an attorney who specializes in federal firearms law. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these Supreme Court updates first. Click that subscribe button because when this decision comes down, probably by June 2026, you need to know immediately what it means for your gun rights. Number 3, how the Supreme Court could rule. 3 basic scenarios. Scenario 1, court upholds the prohibition. Government met Bruen burden showing historical tradition supports disarming substance users. Nothing changes. Marijuana users still prohibited from guns. Catch-22 continues. Scenario 2, court strikes down the prohibition entirely. No sufficient historical tradition of disarming people based solely on substance use without individualized dangerousness finding. Huge gun rights win, potentially opening challenges to other prohibited persons categories. Scenario 3, court strikes down as currently written but allows narrowly tailored version. Maybe prohibit possession while under the influence or with substance abuse disorders, but not blanket bans on occasional users. Practical impacts. If upheld, millions choose between state legal marijuana and gun ownership. Can't have both. Gun owners using marijuana commit federal felonies daily. If struck down entirely, millions can legally use marijuana and own guns. Prohibited persons list shrinks. Form 4473 changes. State and federal laws stop conflicting. If narrow ruling, complicated middle ground. Maybe use marijuana and own guns, but not while high. Maybe recreational use okay, but not with substance abuse disorder. Specifics matter enormously. Number 4, what you need to know right now if you're caught between marijuana use and gun ownership. The Supreme Court case doesn't change current law until decision is issued. Right now, using marijuana and possessing firearms violates federal law. Period. Don't assume favorable ruling. Don't gamble with federal felony charges. Penalties are real. Up to 10 years for possession while being unlawful user, up to 5 years, plus $250,000 fines for lying on Form 4473. Federal prosecutors have wide discretion. Most marijuana users with guns will never be prosecuted, but if you come to law enforcement attention, this charge can be added. Traffic stop with gun and marijuana smell, federal charges. Domestic dispute with guns and drug paraphernalia, federal charges. The prohibition applies even with state medical marijuana cards, even with doctor recommendations, even following every state law. Federal law doesn't care. What to do? Understand the risk. You're violating federal law. Don't lie on Form 4473. If facing legal trouble where marijuana use and gun ownership intersect, get an attorney immediately. Consider whether marijuana or guns is more important. Right now, you can't legally have both. This information could literally save you from a decade in federal prison. Subscribe now because when the Supreme Court decision drops, my next video will break down exactly what you can and can't do based on the ruling. Number 5, let's talk about what happens after the Supreme Court decision and how it could reshape the entire federal prohibited persons framework. The decision in this case won't just affect marijuana users. It will establish principles that apply to all prohibited persons categories. Currently, 18 USC 922G lists 9 categories of people prohibited from possessing firearms. Felons, fugitives, unlawful drug users, people adjudicated as mental defectives, illegal aliens, people dishonorably discharged from the military, people who renounced citizenship, people subject to domestic violence restraining orders, and people convicted of misdemeanor domestic violence. If the Supreme Court strikes down the marijuana user prohibition because there's insufficient historical tradition, what about the other categories? Are they all vulnerable to challenge? Does the illegal alien prohibition have historical support? Does the mental health prohibition? Does the restraining order prohibition? Gun rights groups are already preparing challenges to these other categories. They're waiting to see how the Supreme Court analyzes the marijuana user prohibition because that analysis will guide challenges to everything else on the list. The federal rescheduling issue adds another layer of complexity. If marijuana moves to Schedule 3, does that automatically solve the problem for marijuana users? Schedule 3 substances include ketamine and anabolic steroids. You can legally possess those with a prescription. Would marijuana users with state medical cards suddenly be legal under federal law, even without a Supreme Court decision? Nobody knows for sure because we're in uncharted territory. Federal marijuana prohibition has been in place for decades. State legalization is relatively new. The conflict between state and federal law has been building. Now the Supreme Court is going to resolve it one way or another. Here's your action plan based on this pending Supreme Court case. Action step 1. If you currently use marijuana and own guns, understand you're violating federal law, assess your risk tolerance, consider whether continued marijuana use is worth potential federal felony charges. Action step 2. Do not purchase new firearms while actively using marijuana. Do not lie on Form 4473. If you're asked about drug use, answer truthfully or don't buy the gun. Action step 3. Watch for the Supreme Court decision expected by June 2026. When it drops, read analysis from firearms law experts before making any decisions about marijuana use or gun purchases. Action step 4. If the court strikes down the prohibition, don't immediately assume everything is legal. Watch for ATF guidance on implementation. Watch for whether Form 4473 changes. Wait for legal clarity before acting. Action step 5. If you're facing charges related to marijuana use and gun possession, immediately hire an attorney who specializes in federal firearms law. The Supreme Court case might provide grounds for dismissal or appeal. Here's the bottom line. The Supreme Court is currently hearing arguments in March 2026 on whether the federal government can prohibit marijuana users from owning firearms. This case challenges one of the 9 federal prohibited persons categories under a post-Bruen historical tradition analysis. The stakes are enormous. Millions of Americans use marijuana legally under state law. Millions of Americans own guns. Many people fall into both categories and are technically committing federal felonies every day. The Supreme Court case will decide whether that conflict can continue. The decision could go three ways: uphold the prohibition, strike it down entirely, or create a narrow middle ground. Each outcome has massive implications, not just for marijuana users, but for the entire federal prohibited persons framework. Until the decision comes down, probably by June 2026, the current law stands. Using marijuana and possessing firearms is a federal crime regardless of state law. The penalties are severe. Don't assume the Supreme Court will rule in your favor. Don't gamble with federal felony charges. And look, I spend hours every week tracking Supreme Court cases, analyzing oral arguments, and breaking down what these decisions mean for gun owners. The least you can do is hit that subscribe button so you get the analysis immediately when this decision drops. Subscribe right now. Share this video with any gun owner who uses marijuana or anyone who cares about the intersection of drug laws and gun rights. This is one of the most important Second Amendment cases in years, and most people have no idea it's even happening. Remember, this is educational information about pending Supreme Court litigation. It is not legal advice. If you're affected by these laws or facing related charges, immediately consult with a qualified attorney. Stay informed, stay legal, and watch for this decision because it could change everything about federal gun law. Thanks for watching. I'll see you in the next one where we analyze the oral arguments and predict how the justices might vote.